The real property professional responsibility crossover question from February of 1998 is quite a difficult problem, and it also is a very typical crossover question. Take a look at the calls of the question. 1. What rights and interests do Donna and Paul each have in the road? Discuss. Well, this looks like a classic real property call of the question dealing with an easement, and it turns out that's exactly what it is. 2. May Donna, over Paul's objection, carry out her plans for the road? Discuss. Well, we'll have to take a look at the facts, but basically the question would be whether or not Donna's proposed use exceeds that use that she might reasonably be allowed to do. And then, finally, call of the question 3, has Len violated any rules of professional conduct? Discuss. Well, here we may choose to organize around basic principles of PR, or we may choose to organize around the conduct of the attorney. We've seen both approaches in our seminar on professional responsibility. So we've got a fact pattern here that gives us calls that allow us a fair amount of guesswork as far as organization goes. But we're going to need to read the fact pattern to really get into all that is at issue. So let's do it. Go to the top of the question and let's review the facts together. We first learn that in 1975, Donna asks Stan, someone who is not present in the call of the question, for an easement so that Donna can have better access to her own property. Stan agrees. Len, the lawyer, prepares a deed for an easement for a road 30 feet wide, that's the quote, along a designated path. Len prepares the deed, Stan signs it, and instructs Len to give it to Donna. And unbeknownst to Stan, Len was also Donna's attorney and had advised her to obtain this easement. Well, we don't need to go any farther than this paragraph to see that Len has violated issues related to professional conduct. He's got an undisclosed conflict of interest, and he should have told both of these clients that he was doing business with the other, and his failure to do so is going to subject him to discipline. We'll read on to see what other stupid moves this lawyer makes, if any. In paragraph 2, Stan dies that night, and Len was aware of Stan's death and gave the deed to Donna the next day. And then, like so many people who obtain rights to real property by deed on real property essay questions, Donna fails to record. In paragraph 3, Donna constructs a gravel road 15 feet wide along the designated path. Well, look back to paragraph 1. Her easement is for a 30-foot path. So constructing a 15-foot gravel road along the path probably is no problem. Probably it's within the scope of what she's allowed. But let's anticipate the future. This question is like plenty of other easement questions. We've got a grantee with an express easement who fails to record and then who goes on to use only part of, and not all of, the easement. So if she's going to make an argument for a prescriptive easement or an easement by adverse possession, she's only going to be allowed to claim a prescriptive easement over that part of the actual easement she uses. So we see that Donna has continued to farm her land and use the road. She's repaired it, but she hasn't improved it. Stan's son, Paul, our guy from the call of the question, has inherited Stan's farm and has never objected to Donna's activities. And why should he? We move on to paragraph 4. Now, Donna, in 1997, wants to convert her farm to a commercial development. She wants to use the road as the complex's main entrance, widening it to 30 feet, paving it, and installing utilities under the pavement. Well, this paragraph gives rise to a potential tort theory of liability, that theory being nuisance. And it seems as if her plans for the easement tend to go well beyond those envisioned by Donna and Stan back in 1975. Finally, we've got Paul objecting to Donna's plans. The paved road will interfere with his farming. The area is changing. Some farms have converted to commercial uses, but Paul wants to remain a farmer, and he wants his parcel to remain in farming. Then we get the calls of the question. So, as indicated, this is a straightforward question, but that doesn't make it an easy question. Easements are a fairly tricky area of law, but in my experience, this stuff is harder on the multi-state than it is on the essays. So, take a look at the first call of the question. It asks us about the rights and interests that Donna and Paul have in this road. So, we have to present an answer that talks about each of them separately. Have a look at my outline of issues, and you'll see Section 1A deals with Donna's rights to the road, and 1B deals with Paul's. So to organize it, it seems that Donna's theories are more complicated because they are more nuanced. She's got an express easement, and we know that our discussion of a theory relating to an express interest in land deals with deed, delivery, and title. I've got a brief little line item on the statute of frauds. Then we go into her prescriptive easement theory of liability. Here, again, I use the short bar review approach, the mental, the physical, and the time element. Again, if you happen to be really sharp on the more elaborate approach to adverse possession, you're more than welcome to use that somewhat more elaborate approach. But I don't think we've got time for any great scholarship here on prescriptive easements or anything else, because this is a timed exercise, and we've got to finish it within that time. Next, I consider consent as a theory that would allow Donna to pursue an interest in the road. Next, we consider Paul. His rights are more limited. He has inherited the servient tenement in a situation where his predecessor in interest gave an express easement. So we consider touch and concern, intent, and notice, and then we reach a conclusion. Part 2 is a more straightforward and an easier call than Part 1 because it is narrower. Question 2 only asks us if Donna can carry out her plans for the road. Notice that I go into great depth, even at the outlining stage, into what those plans are. I focus on the width, the pavement, and the underground utilities. I also have a separate section for the potential nuisance liability that Donna may generate for herself if she develops this road the way she wants. And then, finally, we focus on Len and his violations of professional ethics principles. I focus on his duty to disclose, his duty of loyalty, and his duty of competence. It seems to me that this guy has done a particularly lousy job as a lawyer, and we know already that a lot of attorneys on bar exam questions act as if they never should have passed the bar themselves in the first place. So that wraps up a sense of how to organize this answer. And I think you'll agree that organization is the trick here. If you don't organize this answer carefully, you're going to be in trouble, both in terms of finishing on time and also in terms of finishing something that a disinterested reader can understand easily. So now let's take a look at my answer, and I'll show you how I've presented it. Look at the very first thing that I write. I indicate that Donna's theories to have an interest in the land are based on express and prescriptive easement analysis, and then we go into each of them. Notice that with regard to deed, delivery, and title elements to an express easement, I have a separate section for each of those elements. And notice how I introduce it up front in the second paragraph of my answer. Once again, I lead with the facts. I explain what happened, and I explain how the road could be an appurtenant easement. So I even work a little bit of law in to the very first bit of analysis. Then we cover deed, delivery, and title, and it seems evident that the deed analysis is a strong one. Next, we turn to the statute of frauds. It looks as if the deed satisfies the statute. So it seems evident to me that Donna's easement is going to be valid. We focus next on the prescriptive easement analysis, and here again, I focus heavily on the facts and I organize around the elements. The physical element, the mental element, and the time element. It seems to me that she has got a valid express easement to the full road, the full 30 feet, and a valid prescriptive easement to the amount of the road that she actually used, the 15 feet that she's used since 1975. Next, I focus on Paul. Here again, the analysis is even more narrow because I am focusing on Paul's status as the one who inherited the servient tenement. So, in order to determine whether or not the burden on Paul will flow with the land, we need to focus on touch and concern, intent, and notice. Now, I don't spend a lot of time on any of these, but it does seem evident that they are simple. And with regard to notice, here, the fact that Donna didn't record isn't going to prevent Paul from being on notice as to what's going on. He knew about it, and he didn't object. So, I conclude that Donna has a good argument in favor of an express easement, and if that fails, her prescriptive easement analysis should succeed. So, next, we consider whether or not Donna can carry out her plans for the road. And here, I lead with the facts as they relate to the law. She certainly gets to continue using the easement. I don't think there's any dispute about that. But whether she gets to do this new work with the easement is a much different question and a much closer call. So, as we examine Donna's plans, you'll see here I organize around the facts, not around the law, because this is all one issue. Now we focus on the individual facts. With regard to the width of the road, if her claim to the easement succeeds based on the express easement, the width of the road will not be a problem for her. But paving the road is somewhat more problematic. I argue that it was probably foreseen by the parties originally, and although she may be limited to a 15-foot road, it doesn't seem to me that the law will prevent her from paving the road. Next, with regard to the utilities, that may be even more problematic because this appears to me to be outside of what the original parties contemplated. And it may be that a court will conclude that some use of utilities underground will be appropriate, and extensive commercial use is more likely to be deemed excessive, in my judgment. Plus, I focus on her plans as a whole, and it seems evident to me that as to Paul, they may constitute a nuisance. His use and enjoyment of the property may be unreasonably damaged if Donna is allowed to develop this road the way she wants. So, I conclude that Donna probably won't be able to carry out all of her plans over Paul's objection. I think that, ultimately, her plans to expand the use of this easement go so far beyond the scope of the original grant as to be deemed unforeseeable and, thus, preventable. Finally, I focus on Len's violations of professional responsibility principles. Certainly, the duty to disclose has been violated, and also the duty of loyalty. These seem like fairly straightforward and simple issues to me. I don't dwell on them, but I do connect the facts to the law and reach conclusions. Finally, with regard to the duty of competence, it seems here that Len's failure to advise Donna to record the deed is a violation of the duty of competence, although in the bigger picture of my analysis, I don't see how it really causes any harm to the client. So, that wraps up a consideration of this crossover question. Incidentally, this is a question for which answers varied greatly with regard to content. So you may disagree with many of my line items here, particularly with regard to the real property legal issues presented, but here, as elsewhere, a success or failure is going to be judged by the clarity with which you analyze the facts, the sharpness with which you connect them to the applicable issues of law, and the general sense that you have done a competent or incompetent job in the eyes of the chain-smoking solo practitioner who takes a few minutes out of his or her busy day to casually scrutinize your work.